The Federal Court of Canada has upheld Justin Trudeau's government's hotel quarantine program as constitutional. This was a lengthy decision released by the Chief Justice of the Federal Court on Friday, in which the court determined that yes, the hotel quarantine program violates your liberty, but the government is justified in doing so because of, you guessed it, the pandemic. This is the program that Justin Trudeau put in place in January to stem the tide of the so-called variants of concern, a program that would require anyone flying into Canada from outside of the country to stay at their own expense, often costing a couple of $1,000s at least, in a hotel near an airport that the government has designated as an approved accommodation. You get a test while you're there, and regardless of whether that test is positive or negative, you still go home after to do your whole 14-day quarantine. And that was one of the absurdities brought up in the significant constitutional challenge launched by the Justice Center for Constitutional Freedoms as well as Rebel News. And there were a number of criticisms put forward about this. The fact that the hotel quarantine violates your right to liberty, your right to security. It is an insult to injury that you have to pay for this, even though government is mandating it, and that it is a form of unlawful detention. And the court heard all of these rulings over a 3-day-long trial, but at the end of it, the court determined that every single one of these liberty violations, which the court acknowledged exists, are justified because of the scope of the pandemic. A couple of highlights I want to share here. The judge says, although the applicant's right to liberty is engaged, the deprivation of that right was in accordance with the principles of fundamental justice. The judge also says, yes, it's fair to say that staying at one of these hotels constitutes a detention, but the detention is not arbitrary, so therefore it's not illegal. And the judge also gave that boilerplate that is so essential, sadly, in Canadian court decisions, that yes, you have this Charter of Rights and Freedoms that lays out your constitutional liberties, but yeah, I mean, you as might as well don't. The rights and freedoms guaranteed by the Charter are not absolute. This is because it may become necessary to limit rights and freedoms in circumstances where their exercise would be inimical to the realization of collective goals of fundamental importance. The court has determined that the collective goals the government has set out for the pandemic are far more important than the individual liberties that are supposed to be guaranteed by the Charter of Rights and Freedoms. There's that old, very famous quote from Benjamin Franklin, that those who would willingly give up their liberty for a little bit of safety deserve neither liberty nor safety. The judge in this case had a very similar outlook, although on the flip side of it, because he said, like times of war and other crises, pandemics call for sacrifices to save lives and avoid broad-based suffering. If some are unwilling to make such sacrifices and engage in behavior that poses a demonstrated risk to the health and safety of others, the principles of fundamental justice will not prevent the state from performing its essential function of protecting its citizens from that risk. So the ruling is, in a nutshell, that the government has the right to intervene in liberty to protect Canadians. Although the judge also conceded that the issue here is not the effectiveness of the hotel quarantine program, but specifically the objective of it. So if the objective, if the stated purpose matches, even in a peripheral sense, how the government is seeking to fulfill that objective, that's fine to satisfy that it's not arbitrary. The judge even said he wasn't there to weigh its effectiveness, but then you have, on the other hand, the government saying, well, we need to do this because it's the only way we can save lives. A very dark day for freedom in Canada. As for what's next for this, yes, there's going to be an appeal. The length of time it will take to do that makes it probable, however, that this court case will outlast the hotel quarantine itself. This may be taken off the table by the Liberals in the next month or the next 2 months for reasons that have nothing to do with the constitutionality of it. Although, if and when we start to see governments behave in this way again, it will be paramount to have a ruling that tells them no. It's shameful we didn't get that from the federal court, but let's hope as this moves up through the ranks of the Canadian judicial system, there might be some more sensible approaches to this. For True North, I'm Andrew Lawton.